I'm Edward Fitzgerald, the head of Doughty Street Chambers, and I welcome you to this video. Doughty Street Chambers is a well-known chambers for its expertise in criminal appeals and the specialist appeal council that are members of chambers. And over the last 25 years, we've acted in many of the most important cases involving miscarriages of justice. The Birmingham 6, Guildford 4, the Bridgewater case. We've also acted in the case of the Winchester Free and the Cardiff Free. Members of Chambers have acted in the Venables and Thompson appeal, the Sarah Thornton appeal, Michael Stone's case and Derek Bentley's case, as well as the Harry McKenny appeal. We act at all levels, challenging magistrates' courts' decisions, drafting submissions to the Criminal Cases Review Commission, and acting in the higher courts, the Court of Appeal, the Supreme Court and the Privy Council. And members of Chambers are called to many of the other bars worldwide, including, of course, the Northern Ireland Bar. This short video is aimed at helping solicitors to identify points for appeal. It's presented by two members of Chambers, Joel Benathan of Queen's Counsel, who's acted in many leading appeals in recent years and who is the co-author of the Criminal Appeals Handbook, and Paul Taylor, who is the head of the Doughty Street Appeals Unit and is the author of Taylor on Appeals, which he co-authored with many members of Chambers, and a person who has acted in very many criminal appeals over the last decade. I hope you enjoy the appeal and find it useful for your practice and for the work you do on appeals against conviction and sentence.
Classically, you'll be sitting in your office and a letter will come from someone saying, "I'm in prison, I'd rather not be. Can you do my appeal?" And what we'd like to talk about today is the sort of issues that letter is likely to raise and the sort of thoughts you might want to have and the preparation you might want to undertake to try and build an appeal around that. Paul, what's the sort of issues that a letter like that will tend to throw up?
So, letter from inmate. My barrister messed up by not calling witnesses, so you've got a potential ground there of criticism of the trial lawyers. My alibi witness didn't turn up, so you've got potential of fresh evidence from that alibi witness. And the judge is summing up, got the law wrong on the offences and did not leave my defence case to the jury. So you've got an issue about misdirections in the summing up.
Well, let's start with the first of those. Let's talk about criticisms of trial lawyers. I mean, maybe the central point you have to have in mind is this. It's not enough that someone could have done it better. It's not enough there were errors, rudeness, all the rest of it. You actually have to make sure that the fault you're identifying had some impact on the outcome of the case. As always with an appeal, it's all about safety.
So what are the practical issues? You've been instructed as the appellate lawyer, you weren't there at the trial, and as Master Egan, the registrar, points out, you are therefore at a disadvantage. The client gives an account of the things that he says went wrong, but you need to find substantial evidence to support that, and that will be amongst the trial papers. So ask the solicitor for the attendance notes, the conference notes, and of course in order to do that and correspond with the lawyers and put the complaints to them, you will need to advise the client on waiving legal professional privilege.
Now that is a big step to take, but it's a fairly inevitable step in a case like this. It's a big step because that will mean revealing things that might be profoundly unhelpful to the client, and the prosecution will probably see them, the Court of Appeal themselves will probably see them. But it's an inevitable step because if you're criticising your trial lawyers and you don't waive privilege, then the Court of Appeal will simply not be interested. And at some stage you need to actually talk to the trial lawyers. Now, when you do that will depend a bit what the feel of the case is. If the feel of the case is something went wrong that wasn't their fault, then an early courteous letter, as suggested by Master Egan, the registrar, is quite a good way of getting them on board, getting their cooperation. But if you think the appeal is turning into an all-out attack upon their competence, ability, sobriety, whatever it is, then you probably need to wait till later. You need to be fully armed with what the problems are, and you will need to send a document saying, these are the faults, what do you say about them? And we need to move on to our second ground, but to round it up, it's a difficult one because the Court of Appeal fiercely resists the idea that someone unhappy with one set of lawyers buys in a new set of lawyers, and that means the conviction gets overturned when they've had a trial and a jury's reached a verdict and all the evidence. But yet these cases can be won, but they need careful preparation, they need a step-by-step approach, and it is possible to win them. But let's talk about the second ground, fresh evidence. Well, what's the basics?
Fresh evidence is where material which wasn't called at trial is now available for an appeal. It doesn't mean that it wasn't available at trial, just that it wasn't put before the jury. So material has now come forward which you're seeking to rely on to show that the conviction was unsafe.
And the criteria you need to look at is section 23.2 of the Criminal Appeal Act 1968, which lists 4 considerations. Namely, is the evidence capable of belief? Would it have been admissible at the trial? Does it afford a ground for allowing the appeal? And is there a reasonable explanation for not calling it at trial? Now, those are considerations, they're not prerequisites. If one of them is missing, then in theory, you can still have a successful appeal, because the overarching test is the interests of justice. Again, we have to focus on safety. If in the end the Court of Appeal think this conviction is not safe, then even if there wasn't a good reason for not calling it at trial, you can win the appeal. If they don't, then however much you can fulfil those 4 criteria, those 4 considerations more properly stated, you can't. But Paul, how do you go about assessing whether fresh evidence is going to do it for us or not?
So again, in determining whether this fresh evidence impacts on the safety, you need to have a full picture of what went on at trial. You need to obtain all the papers from the trial solicitors. You need to understand what the defence case was at trial, what the prosecution case was at trial, and how this fresh evidence could impact on each of those issues. You need to obtain a statement from you as instructing solicitor as to how this fresh evidence came about. Whether it's an expert's report or whether it's a witness that came forward and it's now being put forward in a statement form.
And once again, we have to go back and talk to the trial lawyers. Easier with fresh evidence, unless you're saying they're at fault for not calling the evidence, because very often with a courteous, friendly approach, a trial lawyer who is still on board will often be prepared to say, yes, this was the key issue, yes, this could have been important evidence, yes, it might have made a difference. Much easier, of course, than if you're attacking them. So again, fresh evidence, the Court of Appeal expect people to put their cards on the table at trial, not to hold material back and then come along later and try and change the outcome after all the expense and trouble of a trial by jury. But powerful fresh evidence, carefully prepared, can win appeals. Third topic, Paul, summing up. What are we looking for if a client is saying the summing up was bad, the judge was biased, the judge got the law wrong? What are the basics you have to do to prepare to consider that?
So the first thing here is you need to put yourself in a position where you can understand what the judge actually said at trial. So that might mean, in the first instance, obtaining the notebooks of trial counsel who took a careful note, hopefully, of the summing up, trying to identify the issues that are raised and that would be the subject of a complaint. If there is something there, or if the trial notes are inadequate, then it may be necessary to get a transcript of the summing up and actually go through it. And that's certainly going to be necessary if you're going to draft grounds.
Quite often, these days at least, the judge will have given the jury a written document with his or her legal directions in it, or a written document with steps to verdict, routes to verdict upon it. That's often a quick and easy way of getting an initial view of what the issues were in the case and whether they were handled well or handled badly. The problem with written directions is that normally trial counsel or advocate will have seen them and will not have objected to them. So we're back in the territory where we may need the cooperation or we may need to deal with the opposition of the trial lawyers. So as always in this area, find the errors, prepare it well, then you do need to go back to the trial lawyers.
Just one thing is that it's worth remembering that an error in itself won't necessarily be the knockout blow for an appeal. The Court of Appeal will look at the summing up as a whole and see how that error fitted in with the rest of the evidence, with the rest of the directions, whether the point that the judge was seeking to make really would have come across to the jury, notwithstanding the error.
Finally, Paul, if we're telling people where they should look for further advice, where do we think they might want to go? I can think of 3 places.
So Doughty Street Appeals Unit runs a free criminal appeals advice line. This is open to all solicitors to phone in. With an initial query, we will give you preliminary advice over the phone, and the other two places are?
Well, it's becoming more like a chat show where people are on tour trying to flog their new books by the minute. I have the pleasure of being the co-author with Greg Stewart and Dan Jones of the Criminal Appeal Handbook. I recommend it. I hope it's a useful way to start to get to grips with issues you need an appeal. But of course, it cannot compare to the great opus. Paul, is another book we should think about on appeals?
Taylor on Criminal Appeals, contributed to and edited by myself, but also written by a team including 12 members of the Doughty Street Appeals Unit.
We can win this case, ladies and gentlemen. Good luck. Keep in touch.